I'm going to try and, so far as possible, stick to the schedule as it's set out there and be reasonably ruthless about that. So it is now time to begin again. And as before, I'm not giving any extended introductions to the speakers. You have it in your materials. And the first speaker of this session is Whitaker, on my right-hand side, who's going to speak on dealing with conflicts of interest when drafting wills for couples. Thank you, Marnie.
I've prepared a brief paper which you'll find in your materials, but there are at least two types of conflict which I didn't deal with in my paper, but I wish to mention them briefly. The first involves a recognition that you may have a conflict and not be able to take on subsequent work because you have drafted a will for a client. For example, because you have learned about a client's assets as a result of taking will instructions, you would be prohibited from acting against that client in a collection matter. That may be obvious, but it sometimes comes up in corporate contexts. The second type of conflict would arise when you are going to be a beneficiary under a client's will. It would be preferable to have another lawyer draft and attend on the execution of the will, but at the very least, if you're going to draft the will, the client must see another lawyer to obtain independent legal advice about the will and to execute the will. And I don't believe it is independent legal advice if you send that client to another lawyer in your own firm. But the type of conflict of interest, which I think I was asked to deal with, involves acting for two or possibly more clients at the same time, clients whose interests may be identical or may be quite different. In this situation, lawyers have an obligation not to use information obtained from a client against that client and not to prefer the interests of one client over another client. Rule number 5 of the Law Society of Upper Canada Rules of Professional Conduct is entitled Conflict of Interest. The rule provides that the lawyer must not advise or represent both sides of a dispute and save after adequate disclosure to and with the consent of the client or prospective client concerned, should not act or continue to act in a matter where there is or is likely to be a conflict of interest. The commentary on the rule explains the rule and discusses its application in various situations. The effect of the commentary is to provide that while lawyers may act for two or more parties who may potentially be in a conflict of interest with each other, the lawyer must ensure that the clients have sufficient information to enable them to make an informed decision about whether or not to continue with the same lawyer, despite the possibility of a conflict of interest. In preparing to write a brief paper on this topic, I reviewed several excellent papers written by other lawyers. They contain good analyses of the conflict issues involved and lengthy discussions about the ethical questions arising from conflicts. What they didn't do, I thought, was to discuss the avoidance of conflicts in the first place. In providing good service to clients, lawyers must foresee potential problems, and a conflict of interest between two clients, at least in theory, is a foreseeable event. I think this applies not just to couples, but to any two clients who wish to come in together to see you, whether they be a married couple, a common law or same-sex couple, a parent and adult child, or adult siblings residing together. I thought at first I could differentiate among these types of pairs based on what was likely to be their level of financial and emotional interdependence. But then I realized that was a false distinction, and I couldn't presume to generalize about other people's relationships. While it would have permitted me to draw neat categories if I assumed that adult siblings, for instance, lived together but lived quite separate lives, whereas married couples would live lives of mutual trust and sharing, I know pairs, as I'm sure you do, where these generalizations don't stand up. So rather than use my biases about what the relationships between pairs of clients would be and have different guidelines for each relationship, I thought it was simpler to have guidelines that would be based on the information that would come from the clients. So the first guideline, which I think is significant, is, who is your client? When two people come in to see you, but one does all the talking, are they both your clients? I think this is actually more of a problem in civil litigation matters. We've all heard of the professional liability example where two people come in to see the lawyer. One talks about the car accident he was in and discusses bringing an action against the driver of the other car. Only after the limitation period has expired does the lawyer realize that the other person present in the office was also in the car accident and has assumed that the lawyer is representing his interests as well. Almost any lay person appearing in a lawyer's office may assume that he or she is a client and that the lawyer owes a fiduciary duty to him or her. In wills matters, it's not likely to be a matter of liability if you don't prepare the will as expected, unless the client dies while waiting for you to draft it. But it can be embarrassing if you draft only one will when two were expected, or vice versa. So clarify whom you are supposed to do the work for. Both people who are present or only one. While the answer may seem obvious in the case of married couples, it may not be obvious in the case of a parent and an adult child. So ask the people while they're present in your office. The second guideline is, determine at the outset what your retainer is. Who is counting on you to do your job? Whom can you take instructions from? And whom are you obliged to give information to? If it is a joint retainer, do the clients understand that this means you can't keep information or instructions received from one of them secret from the other? For most married couples who meet with you together and contribute equally to the giving of instructions, it is likely that your retainer is from both of them, and that they would agree that any information and advice is from and to both of them. But it's worth clarifying at the beginning. Point out that you are acting for both of them, and that any information one gives you must be shared with the other. This may not prevent one client from trying to give you separate secret instructions later, but at least the client won't be surprised when you advise him that you can't act on those new instructions without advising the other client of the new instructions that were given. The situation is more complicated when you meet with a parent and adult child who reside together. Are you being given a joint retainer so that anything either of them tells you must be shared with both of them? Or is the child merely a chauffeur and the parent wants you to keep his information and instructions confidential? If it is the latter, make sure the child understands this and knows that he or she cannot rely on you to make sure the child receives particular benefits under the parent's will. As I noted in my paper, potential conflicts of interest and lawsuits over breach of fiduciary obligations are best avoided by an early understanding as to the identity of the client and the terms of the lawyer's retainer. Thank you.
Thank you very much, Marnie. And so next, Brian Schnurr, remuneration of executors and trustees.
Thank you, Tim. So 6 minutes, no jokes, no quips, just down to business. With my paper regarding executors' remuneration, I've also included, with the permission of Jordan Ayton, a second paper, which is quite a recent paper done by Jordan with respect to the issues of executors' compensation. So I thought that that might be useful to you at some time. So that's included as an appendix, and that starts at page 1221 of my tab. Now, in my paper, I have, in essence, covered 4 areas when talking about executors' compensation. Development of the tariff guideline, percentage guideline, call it what you will. And that's of course, 2.5% on receipts and disbursements, and 0.2% of the average annual value as a care and management fee. Secondly, I've dealt with the tension between the tariff guideline and the cases that talk about the 5 factors by which trustees' compensation is to be quantified, and the factors are set out, you know them, but they're set out at page 2. Then I deal with the Reed-Jeffries decision and the attempt to come to some kind of balance between those 2 ways of measuring executors' compensation. And then finally I discuss the cases that went to the Court of Appeal together, 3 cases, Flaska, Lang, and Gordon, in late 1998. And then I do get into some specific problems and issues such as special fees and pre-taking and approaches in large estates. Today, just 2 areas of comment. Firstly, the effect of the Lang, Flaska, and Gordon cases that I refer to in the material. These cases represented the first time in about 50 years that the issue of executors' compensation had been dealt with by the Ontario Court of Appeal, so they deserve some attention when you're dealing with that area, either on behalf of beneficiaries challenging the amount of comp or on behalf of the executor seeking the compensation. 3 points, I think, are the main points from those 3 cases. One is that the Court of Appeal adopted, in essence, the Jeffries approach as a balance between predictability, i.e. reliance on the tariff guideline, and the need to tailor compensation to the circumstances of the case, the 5 factors. And they quote the core of the reasons for decision by Mr. Justice Killeen, quoted approvingly in those 3 cases. Secondly, the Court of Appeal confirmed that when you're looking at the 5 factors, despite the fact that only 2 of the factors are objective, and of those 2, time spent is really the only one, because the other one is the size of the estate, that helps very much, in my view, assessing, quantifying compensation. Time spent, said the court, is only one of the 5 factors. It is not to be given paramountcy over any of the other 4. And lastly, and particularly if you're acting for an executor and you're trying to justify in argument the application of the tariff guideline, note that the court implicitly accepts the decision of the divisional court in the Lang case, and in so doing, one certainly can argue that the court has accepted the following statement, which is in the divisional court decision regarding the tariff guideline. And the quote is from the divisional court that the tariff guideline should only be deviated from when it is shown that the estate is either unusually complex or exceptionally simple. End of quote. Now, the second area of comment that I want to mention relates to the increase in the tariff guideline itself. There have been 2 legislative changes in the last couple of months that, in my view, are very much going to take the lead in pushing this percentage guideline that we've had with us for 25 years to a higher level. Regulation 2695 under the Substitute Decisions Act, Section 1, sets out the compensation for attorneys of mentally incompetent persons under a power of attorney and guardians of property for mental incompetent persons. And up until 2.5 months ago, it set that out, you won't be surprised to know, consistent with what we refer to as the tariff guideline, 2.5% in and out, 2/5 of 1% care and management fee. As of April 1st, that regulation was amended and the percentages went up to 3% in and out and 3/5 of 1% care and management fee. Of course, subject to adjustment by the court, but of course the tariff guideline has always been subject to adjustment by the court. My point is that in terms of what the benchmark is by percentages, the bar, I think, is being raised. The second legislative change relates to the public guardian and trustee, and under Section 8 of the Public Guardian and Trustee Act and regulations, the tariff guideline percentages were set out as the compensation that the PGT was entitled to on administering estates and trusts within that office. And again, it was 2.5 in and out and 2/5 of 1% care and management fee. And again, as of May 1st, 2000, that's gone up to 3% in and out, 3/5 of 1% care and management fee. So 2 trends I leave you with, particularly trends that are helpful in my view to the executor who is trying to maximize the compensation that he, she, it, they, whatever will receive. One is that I think the Ontario Court of Appeal has given a nod in the direction of predictability as a reason for the general support of the importance and use of tariff guidelines. And secondly, based on the legislative increases in percentages resulting in the from the two examples I just gave you, there's going to be increasing justification to increase the percentages which we use as a benchmark. Those are my comments, and thank you very much.
Thank you very much, Brian. And next is Lindsay Histrop, power of an estate trustee during litigation. That's fine then.
I think I'll speak from here and then I can save time walking back and forth. My topic deals strictly with the powers of the estate trustee, and I am also going to refer you to a paper by Jordan Ayton. He's been very prolific in the last little while, and he wrote a paper. It's referenced at the end of my notes, and it's approximately a year ago, where he deals also with issues of procedure and questions of who should be appointed, etc. So I recommend you to Jordan's paper. The statutory authority for the powers of an estate trustee during litigation comes from Section 28 of the Estates Act, and essentially provides that the administrator has all the rights and powers of a general administrator other than the right of distributing the residue of the property, and every such administrator is subject to the immediate control and direction of the court, and the court may direct that such administrator shall receive out of the property of the deceased such reasonable remuneration as the court considers proper. The provision itself looks very straightforward, but of course in practical application it's anything but. The responsibility then is to administer, subject to the court order confirming the appointment, and also subject to the terms of the will, or we may have multiple wills, because this is generally a situation where there may be a contestation of the validity of a will. Ideally, the court order will also address areas where an estate trustee's responsibility or authority is uncertain, because obviously there are a lot of areas where guidance may be necessary, and if these can be anticipated at the time of the appointment, then it saves applications returning to court for advice and direction as to what the estate trustee during litigation should do. And by the way, just the terminology, this used to be called the administrator pendente lite. So if you look at any historic references, the reference would be somewhat different to the title of this position. Primary responsibilities, I've referred you to the Renock decision, and of course everybody remembers that decision as the one that held that it's not proper to pre-take compensation. However, also in that decision there was an interesting examination of an issue regarding the sale of property to pay debts. And the administrators had sold a valuable piece of real estate under the authority of a court order, but the beneficiaries felt that the compensation should be reduced because indeed apparently they sold the property, and it was subsequently sold very quickly afterwards for $1.5 million more than the estate trustee during litigation had got for it. So obviously it's very, very difficult issues for an estate trustee during litigation to deal with, although sometimes there obviously assets have to be sold to satisfy debts. I've listed what really appear to be fairly straightforward routine responsibilities: ascertain the assets, determine the liabilities, preservation of the assets, insurance coverage, which of course applies to any administrator or executor, custodial issues. And I raise this because even though, for example, personal articles may not have value, sometimes they do, and it's obvious that there's valuable paintings or antiques that need to be safeguarded, but sometimes it's the cups and saucers that really aren't worth very much except from a sentimental point of view, and they have to be safeguarded so that family members don't remove them and that way deprive the beneficiary of the personal articles. Investment considerations I've also mentioned, particularly in light of Section 27 of the Trustee Act, which requires, as a mandatory requirement now, to diversify estate assets. And it's an interesting question, the extent to which that's going to apply to an estate trustee during litigation. Preparation and filing of tax returns. Again, this may look like a straightforward exercise, but if there are rollovers under the terms of the will, but the will's being contested, then there's a good question as to whether the terminal tax return can be filed on the basis that those rollovers are going to take place. So these aren't easy issues, and obviously explanatory letters are going to have to go with the terminal returns to Revenue Canada to explain basically what the situation is, and until the litigation's resolved, at which time an amended return might have to be filed. Satisfying legal obligations, and I've included there in particular, including support obligations under a separation agreement. If these obligations are binding on the estate, then the estate trustee during litigation has to continue to honor them until there's an order varying the separation agreement. Another more obvious and common one would be simply mortgage payments. Maintaining estate accounts, again, it's really just stating the obvious, and where appropriate, requesting an accounting by attorneys or guardians of property for the person. Now, I have a heading, responsibilities where discretion may have to be exercised. And the more I look at that heading, the more I realize that probably if there's doubt or any uncertainty on the part of the estate trustees, they're going to want the benefit of an order of the court unless all the parties consent to taking certain steps. And obviously, selling a major asset to pay debts is one of those steps. The question of advances for the support of dependents, I guess there's really two levels of this issue. One is where the dependents are clearly dependents under the statute, for example, a minor child. And then there's those gray areas where there may be a common law spouse who's lived with the deceased for 2.5 or 2 3/4 years, and do they qualify under the statute, and so on. Obviously, where there's clearly a dependency with respect to minor children, then steps have to be taken to protect those interests. And there is a decision of the Ontario Surrogate Court where it was held that making advances for the support of the widow did not constitute distribution of the residue of the estate, so that it was something that the estate trustee during litigation could do. However, again, you'd have to tread very carefully to take steps to determine what appropriate support is without getting a court order. So really in those circumstances, an order for interim support is appropriate. Major change in investment policy, as I mentioned earlier, because of Section 27 of the Trustee Act, if the estate trustee during litigation considers that the portfolio of investments should be modified in some way, I mean, that would be a situation where I would be at least trying to get the consent of all the parties before taking any major steps. Another major issue that's been highlighted by other commentators is the production of medical records and solicitor's notes, and also financial records from third parties. Because we are in the midst of litigation regarding the validity of the will, this is information that all the parties are going to want to receive, and so that the estate trustee during litigation isn't in any doubt in that regard. It makes sense to have the original order which appoints the estate trustee during litigation to address the production of medical records and disclosure to all parties. The estate trustee during litigation also has the authority to settle claims, and that's under Section 48 of the Trustee Act. But naturally, if it's a claim that affects any party to the litigation, consent of all parties is going to be important in that situation as well. And finally, just other roles that that the estate trustee during litigation may play or may not, depending on the circumstances. They may have a role in assisting the parties in resolving the litigation, and that will be determined much by the personalities involved, and possibility of participating in the mediation process, assisting in calculation of net family property, and if the estate's insolvent or there's abatement, then they also have to deal with those issues. That's it. Thank you.
Thanks so much, Lindsay. So our next speaker is Stephen Grant, who I see has arrived. Fancy dress. Stephen doesn't know we're not introducing people except by their names, but Stephen's a family lawyer, and I guess they always dress like this. So Stephen, it's a check from the Law Society for a very large amount of money for doing this.
It's a free pen, I think.
Stephen is speaking on setting aside transactions regarding FLA equalization entitlements.
Thank you. I am in the middle of a trial that does have actually this one issue that coincidentally I'm talking about today. In this case that I'm involved in, my client settled a trust about, must be about 10, 12 years ago. And the argument is that had he not settled this trust for the benefit of all of his children, there would be more money in his net family property and therefore available to equalization for the spouse. I never thought honestly much about this until the Stone decision came out, which is what Tim asked me to talk about today, and I'll talk about it for a few minutes because I'm now plagued by this problem. Let me tell you a couple of seconds about Stone, the parties. I think they were in London, and there was a second marriage for both the parties, and Mr. Stone had assets of about $2 million. Mrs. Stone had a little bit of assets, but not much. And shortly before, Mr. Stone learned that he was dying. And as it happens, Mrs. Stone as well was rather ill too, but Mr. Stone learned that he was dying, and when he learned he was dying, he transferred about $1.3 million worth of assets to his children, thereby taking that money out of his pool that would otherwise be available for equalization by Mrs. Stone on his death. And and he did this, at least according to the judgment, it was rather surreptitious in the way that he did it, and there seems to have been possibly some misleading of the activity that was going on. So Mr. Stone died, and Mrs. Stone went to get her equalization claim, only to learn that the pool of assets available for equalization had been reduced by $1.3 million. So the question for Mr. Justice Hawken was what to do about the assets that were no longer in the pool and available for equalization. And what Mr. Justice Hawken did was to say that these assets had left the pool by means of a fraudulent conveyance. They had been fraudulently conveyed by Mr. Stone to his offspring. To arrive at, and I want to say this about the fraudulent conveyance, to do that he had to find that Mrs. Stone stood in the position of creditor vis-a-vis Mr. Stone, who was the notional debtor. That's the problem actually that I have with the case. But I've read this case now a dozen times because I've been really perplexed by it and rather plagued by it, because it really runs counter to the fundamental tenet of the Family Law Act, namely that parties are effectively separate as to property until one of the triggering events occurs, namely marriage breakdown by separation, divorce, or death. And what Justice Hawken did was to say that there exists, and I guess this is the troubling part for me, there exists, he says, a running account between spouses. So presumably that means a running account from the day the parties marry until the marriage ends, so that each party, you wouldn't know which, they would change positions from various times presumably, but they operate in a debtor-creditor relationship throughout the marriage, and at the end of the marriage somebody has to account to the other in case of any assets that leave the marital pool. Again, this is really troubling for me, not so much as a family lawyer, but I think in terms of the commercial realities, in terms of the estate's realities, in terms of real estate realities, in terms of business realities, this is, in my mind, an extension of what the Act is about, of the debtor-creditor nature of the Family Law Act that may be unwarranted. Just as an aside, it seemed to me that the equities of the situation, although I don't think it seemed to have been done very well, but the equities of the situation, I don't really find troubling. I don't see why Mr. Stone shouldn't have been able to leave his assets essentially to his children as against Mrs. Stone's children, which was the effect of what he was doing. Now, Mrs. Stone's legitimate expectation of what she would receive on his death was obviously thwarted. So what it comes down to, and by the way, I'm virtually certain that Stone & Stone is under appeal. Anybody know for sure? I'm sure it's under appeal. It is for sure. So what the balance is this. Is the right to alienate property through the marriage as against needing to preserve an appropriate, I suppose, pool for equalization purposes, either at the end of the marriage on marriage breakdown or on somebody's death. I think those are the competing interests. Now bear in mind two particular provisions of the family law. One is section 5.3, which Justice Hawken does talk about. We in our family law bar call it the Alzheimer's section, but it's the one that allows people to make an equalization claim during the marriage if somebody is dissipating assets. And he said that had Mrs. Stone known about what was going on, she would have been able to invoke this. This has adverse consequences for somebody because if they invoke it once, the Act says that's the only time you can invoke it and you're done. At that point, you're finished. So it has certain adverse consequences. The other thing, though, that is important is that I think that this is really more a matter of unconscionable. And when you're looking at unconscionable, I think you then have to look at the reasons for the disposition, the rationale for the disposition, in other words, whether it was done in good faith. Because a judge has power under Section 5.6 of our Act to basically find an unequal equalization if somebody has improvidently depleted, intentionally, improvidence in another section, but intentionally depleted his or her property. It's inescapable that, for example, in the case that I'm involved in now, my client intentionally depleted his property. In other words, he intentionally alienated property from his own asset pool, but it was the purpose of it was to set up a trust for the benefit of all of his children. I think the court will then have to weigh, it's not really so much an issue in my case, but in any case, a court will have to weigh whether that purpose and the extent of the alienation was appropriate. If it doesn't fall, if it falls below the unconscionable threshold, I don't think we'll see a problem. If it falls above the unconscionable threshold, we will see a problem. Justice Hawken considered that problem in Stone, but said that because he wasn't going to resort to it because there wasn't enough money left in the pool to be able to award Mrs. Stone an unequal equalization. That's why, and I guess this is why I'm not as troubled as I was at first reading of this case, that's why he resorted to the Fraudulent Conveyances Act, as far as I can tell, in order to drag the assets back into the pool to allow for the appropriate allocation to be made. So what's interesting about this, I think, for your purposes and certainly mine, is the extent to which the conflict which is between the right to alienate or transfer property bona fide conflicts with the obligation not to intentionally deplete one's assets so that there's a reasonable pool of assets available for equalization at the end of the marriage. And I guess what we will see is what the Court of Appeal does about this in terms of trying to find the appropriate balance of this problem. Thank you.
Thank you very much, Stephen. Now, we're going to do a switch over, so if the people here could vacate their chairs, and Alice, Joseffer, Archie Rabinowitz, and Jennifer Pfuetzner, all of whom I hope are here, come up. But if those who are going down could stay around, if possible, that would be appreciated in case there are any questions that people might wish to raise at the end. Can you stay around?
I can't. I'm in the middle of a trial.
But in the middle? You mean you're going back?
I actually had asked for a break to
Ah, Stephen.
be able to come over.
Oh, thank you. Doesn't matter. I mean, sit wherever you like. Okay. So you're next. Hi, Archie. How you doing? I didn't realize that Stephen was speaking literally when he said he was in the middle of a trial. He says he's going back to the trial and got a short adjournment to come here. So that's quite something. We will just carry straight on, and everybody is now here. And so the next speaker is Alice Joseffer on my right-hand side, who is going to speak on implications of including U.S. persons as beneficiaries under wills. Thank you, Alice.
Good afternoon. You're lucky or unlucky. I don't have to leave for a trial immediately, but I promise not to run over.
You won't get the chance.
I know. And of course, the topic is implications of including U.S. persons as beneficiaries under wills. And the point, of course, is that some planning must be done in order to avoid a transfer to a U.S. person becoming subject to the U.S. estate tax, a tax that would be imposed on the estate of the U.S. person at the time of that person's death at fair market value, basically. It's a tax that is imposed based on the fair market value of the assets. So although you may be planning for a Canadian, you need to keep in mind whether or not there might be a U.S. beneficiary, because although there wouldn't be an immediate U.S. tax, there would be an ultimate U.S. tax, which of course is to be avoided. My paper is at tab 15, and in doing it, I assumed a bit of knowledge and familiarity with the U.S. estate tax. So if that's problematic for anyone, let me know and I'll accommodate that. Now you may wonder, if you've been reading in the press about the possible elimination of the U.S. estate tax, you may be thinking, gee, is this really an issue? Can we just sort of not deal with this? My view is it definitely should be dealt with. The Death Tax Elimination Act was passed by the House of Representatives last week. It's probably going to meet some opposition, but may pass the Senate. President Clinton has either threatened or promised, depending on your point of view, I suppose, to veto it if it is passed. There might be enough votes for an override of a veto, in which case it could go through. But it's not actually a full repeal. It's a phase down. The phase down would become effective in 2010. And it's unlikely that even if it were to pass, it would remain law very long. As a practical matter, although there's a lot of hoopla about it, there's about 2% of estates that are subject to the U.S. estate tax. And of course, part of the reason the number is small is because folks like us do planning. The revenue loss for the FISC in the event that this were to become law in terms of the phase down would be approximately $50 billion per year. And so the likelihood of there being any really significant change is small. Moreover, if there were that type of a change, then there would be changes in what we refer to as step-up in basis or carryover basis in property at death. And if the estate tax were to be repealed, then the opportunity to step up basis to fair market value at date of death would be gone. So then we would be planning for a gains tax, which brings us back to the fact that there would be property in the hands of a U.S. person that would ultimately be subject to tax. And of course, if that can be avoided, that's what we should be talking about. There are certain techniques and objectives in terms of doing this type of planning. And in order to focus the topic a bit more narrowly for this afternoon, I'm focusing on an example we see fairly frequently in terms of couples residing in Canada. One is a Canadian citizen, one is a U.S. citizen. And the planning for both needs to be coordinated. I touch on both halves of the equation, so to speak, in my paper. I'm just going to mention a few points in terms of planning for one side of it this afternoon. And the very specific techniques and objectives for planning for a Canadian's estate where the Canadian spouse is a U.S. citizen would be, first, none of the Canadian's assets should pass either outright or otherwise to the U.S. spouse in a manner that would make them subject to U.S. estate tax on the death of the U.S. spouse. Second, the Canadian's will should include a spousal trust to benefit the U.S. spouse, and also to permit Canadian tax to be deferred. In addition to planning for U.S. spouse, Canadian spouse, there needs to be the parallel planning for both U.S. and Canadian taxation. The terms of the trust should not give the U.S. spouse rights that would cause the trust to be subject to U.S. tax in the person's estate. So the terms of the trust are critical. because an interest in a trust can be included in a U.S. citizen's taxable estate. And third, the primary beneficiary of the Canadian's life insurance should be the spousal trust, not the U.S. spouse. So the ways to proceed then are addressing asset ownership and allocation, drafting with the proper terms, and planning for life insurance proceeds. In terms of asset ownership and allocation, it's key to limit the U.S. spouse's assets. Currently, there's an exemption amount of $675,000, which is in effect free of U.S. estate tax. But the key then is to make sure that the U.S. spouse does not have more than that exemption equivalent in his or her estate. That amount is increasing under current law to $1 million U.S. dollars in the year 2006. So limiting what's in the person's future estate is one technique. Avoiding jointly owned property is critical. Now, this doesn't pass by will, of course, but by operation of law. And if, for example, our Canadian spouse, U.S. spouse team jointly own property, and the Canadian spouse dies first, all of the value of the property will be includable in the U.S. survivor's estate. So we need to carefully work through the jointly held property issue. Of course, the rules can become more complicated, and in a situation where the property is, for example, U.S. situs property, then a non-resident can be subject to U.S. estate tax on that as well. At this point, we're focusing on half of the equation, but if there's jointly owned property, such as the common vacation property, that becomes an issue. So first step is really looking at the asset schedules and making sure that property is owned separately. Then in terms of drafting the trust, I've given you sample terms that it is possible to include in a trust without the trust becoming subject to U.S. estate tax as a result. So you might want to look through them. Again, they're illustrative. Any trust would have to be looked at in its totality to determine what the implications would be. I mentioned planning with respect to life insurance, the importance of not having life insurance proceeds going to a U.S. beneficiary. Again, assets that would ultimately be subject to U.S. estate tax. And one reminder, too, is that the U.S. beneficiary is going to have to report bequests from foreign decedents if the aggregate amount is over $100,000. So there is a U.S. reporting requirement with respect to receipts of gifts. And as I noted, there is another half of the equation, and you have to put both of them together to make this work.
Next is Archie Rabinowitz, recent cases affecting probate planning. Archie.
Thank you. I'm always embarrassed to be speaking at one of these conferences with who I always will remember as Professor Youdan at my side, who caught me sleeping in his class at Western on more than one occasion. But in any event, this is his way of seeking revenge. I'm here just to briefly speak about some recent cases and their impact on probate planning. I've not attempted to do an exhaustive analysis of this area, but merely to focus on cases dealing with one of the, not the only, but certainly one of the common methods for probate planning, which is the use of multiple wills. I have included as the first appendix to my paper a copy of the Yourig decision, the Supreme Court of Canada's decision dealing with the constitutionality of what used to be known as probate fees. I'm not going to spend any time on that because we all know what the bad news is. Namely that the only people who ultimately saved any money was the Yourig family, and everybody else is now, we just call it something else. It's a tax, and so be it. So I'm not going to spend much time on that. The second case that I've set out is something called the Granovsky estate case, whereby Madam Justice Greer confirmed the appropriateness of and validity of using multiple wills, and the fact that you don't necessarily have to get probate or apply for probate for both wills. You can separate the assets out, and if anyone needs any clarification on what that is, I think Madam Justice Greer deals with that. The issue then was, given that the Crown abandoned its appeal of the Granovsky decision, and I guess what practitioners in the province were appreciating was that the use of multiple wills was alive and well, the question was then going to become, were there going to be subsequent cases which were going to suppose drive a wedge into the use of multiple wills that would thereby limit their availability. It turns out in the two cases that I've referred to and that I just want to briefly address today, the Silver estate and the Carmichael estate, and again copies of those decisions are reproduced as an appendix, are the conclusion is that not only has the court not seemed to come back and narrow down on the use and scope of multiple wills, but it has in fact reaffirmed the validity of the use of multiple wills, which I think is welcome news for those of you who practice in the estate planning world. The Silver estate was what was going to be potentially my first loss on a uncontested over-the-counter application, which we have a ceremony at my firm that if you come back to the office admitting that you've lost one of these or that it's been rejected, you have to go through a ceremonial gown burning process. And well, I came close, but ultimately saved my gown. The situation was in Silver, there were two wills. One was submitted for probate. One of the wills was not submitted for probate. And there was a voluntary passing of accounts undertaken by the estate trustees under both the primary and the secondary will. We, of course, had to deal with the Public Guardian and Trustee's Office, the Office of the Children's Lawyer. We satisfied any questions that those good offices raised, and ultimately I think got notices of no objection or some equivalent to that, and went ahead and thought we were just merely proceeding with an over-the-counter application. Mr. Justice Cullity got a hold of it and decided otherwise, and questioned the propriety and jurisdiction of the court to deal with a passing of accounts, not with respect to the primary estate where probate had been granted, but rather with respect to the secondary estate where probate had not been granted, and directed that we go before a hearing. I then called up representatives of those two offices that I mentioned, and I said, was this a concern that anyone at your offices had raised? They said no. That only left one person. That, of course, was either Mr. Justice Cullity or somebody on the bench. We then prepared, I suppose, legal arguments on the issue, and Madam Justice Haley reserved and ultimately released her decision. She concluded that the fact that a will had not been probated should not serve as any kind of impediment to the ability of the estate trustees under that unprobated will to pass their accounts or to be cited by the court to pass their accounts. So there was no, I don't think there was a material distinction made between whether or not it was a voluntary passing, as was the case in Silver, or an involuntary passing. The court went out of its way to point out the fact that there were some problems in the language of the rules, which seemed to suggest that part of the package that you have to prepare for a passing of accounts is a copy of probate, but outweighed, I suppose what outweighed that for Her Honor was the fact that it wouldn't make sense for there to be an impediment for a beneficiary or for the court to assume jurisdiction over the review of the actions undertaken by estate trustees, where no one involved in the estate up till then, beneficiary or otherwise, had ever questioned the validity of the will or had questioned the status of the estate trustee to call him or herself estate trustee. So ultimately, that application then was granted. Very briefly then in the Carmichael decision, which was also heard and analyzed by Madam Justice Haley, interestingly enough, both in Silver and Carmichael, these issues were, as I mentioned in the Silver case, raised by the court and not by any of the parties. In the Carmichael, there was a situation simply where an individual obviously named Carmichael, passed away. There was a will. Carmichael died testate. The named estate trustee began to undertake administration of the estate without obtaining probate. No one ever questioned the validity of the will. No one ever questioned the propriety, or, sorry, not the propriety, but the status of the named estate trustee to hold, I don't know if it was a he or she, as hold themselves out as estate trustee. There was a dispute that arose with respect to the administration of the estate. There were 3 estate trustees in Carmichael. One of the estate trustees was the widow, and the issue then became whether or not the court could remove an estate trustee for cause where there was no probate. And for reasons which I'm sure you'll be fascinated to read in the published reasons, Her Honor concluded that that, again, should not be an impediment. So in conclusion, I think that the recent cases have reaffirmed the validity of the use of multiple wills in probate planning, and I think that it's alive and well. So with that, I will keep quiet. Thank you.
Thank you very much, Archie. And so last but definitely not least, Jennifer Pfuetzner, use of powers of attorney in estate planning for incompetent persons.
Thank you. I hope everyone can see me over this podium. I'm going to be speaking about the use of powers of attorney in estate planning for incompetent people. And the topic that I want to look at is, what are the powers of the attorney to engage in estate planning on behalf of the incompetent person where the power of attorney does not contain any specific instructions or directions as to their ability to do so. The first place that we can look at is the Substitute Decisions Act to see whether the attorney has any specific powers in this regard. The Act basically provides that the attorney, subject to what's in the power of attorney, is given the power to do anything that the incompetent person could do except to make a will. This is, however, subject, first of all, to the attorney's fiduciary duties to act in the best interests of the incompetent person. And second of all, the Substitute Decisions Act specifically provides that gifts to relatives and friends can only be made if the incompetent person expressed intentions that such gifts be made while they were competent. So the Act actually is fairly limiting in terms of what the person can do. If an attorney does wish to engage in more sophisticated estate planning on behalf of the incompetent person and to do things that would not clearly be authorized under the terms of the Act, they should seriously consider getting court approval for what they're planning on doing. I'm going to look at 4 recent Canadian cases that have looked at these issues. Mary Louise Dickson touched on 2 of them earlier, but I'm going to hopefully quickly look at them in a little more detail. The first case is the case of Ree Goodman, which was a British Columbia Supreme Court case. The proposal there was to transfer 2 houses to the 2 children of the incompetent person, 1 to each child. There was no evidence produced as to any financial need on the part of the children that this was going to alleviate. There was no independent evidence either that the grantor would have made these transfers if she were competent, and there was no evidence of any tax savings that would result from the transfers. In fact, there was evidence that capital gains tax could be triggered on the transfers. The application was not surprisingly denied on the basis that there was no benefit to any of this to the incompetent person, and there was no real benefit from a tax point of view, and there was no financial need on the part of the children. The second case was called Ree Bradley, which was also a BC case. In that case, the incompetent person was a U.S. citizen who had fairly substantial assets. She was age 64 and had suffered a brain hemorrhage, and her life expectancy at that point was uncertain. The plan was to make gifts to her husband, children, and I believe grandchildren in order to reduce her estate so that on her death the amount of U.S. estate tax payable would be less. There was evidence that she had made gifts to her sons in the past, and there's also evidence that she had sought U.S. estate tax advice prior to becoming incompetent. The Supreme Court in British Columbia allowed the application and approved the gifts on the basis that the grantor would have made these gifts if capable and that there was a significant tax savings to be had. However, the case then went to the British Columbia Court of Appeal, and the Court of Appeal reversed the decision on the basis that the contemplated gifts would deplete the incompetent person's estate to an extent that did not adequately take into account her possible future needs, considering her life expectancy and the fact that the cost of her care may increase in the future. The third case is O'Hagan versus O'Hagan, again from British Columbia. That was a case where the incompetent person was a very elderly man who had significant assets worth more than $7 million. And his primary assets were shares in a private company. The proposal was for a corporate reorganization and estate freeze for the purpose of reducing the amount of capital gains tax that would be payable on his death. The Supreme Court did not approve the plan on the basis that it involved changes to the assets of the person that were much more radical than any that had ever been approved before by the court. It appears that the judge at first instance didn't quite understand the nature of the plan and the proposal. This case was also appealed, and the Court of Appeal reversed the decision and approved the estate freeze on the basis that it provided significant tax savings for the estate and hence the incompetent person's future beneficiaries. And it also had the result of not diminishing his estate in any way. So there was no question that he would not continue to be well cared for the rest of his life. The fourth case that I'm going to touch on is Banton versus Banton, which is an Ontario General Division case. In that case, attorneys had transferred the bulk of an incompetent person's assets to an irrevocable inter vivos trust for the purpose of protecting his assets. They were concerned about his relationship with a much younger woman who he eventually married. The trust provided that the incompetent person would benefit from the income and capital during his lifetime, but that on his death it would vest in his children with provision for any deceased child's issue to take in their place. Mr. Justice Cullity considered whether the creation of this trust was a proper exercise of the attorney's powers, and he found that although it was proper for the attorneys to take steps to protect the incompetent person's assets, the trust that they purported to create went too far in that it created these irrevocable remainder interests in the incompetent person's issue. In evaluating whether the trust was properly created, Justice Cullity found that the question to be considered involved not only a consideration of whether the creation of the trust would improve the incompetent person's situation, but whether its effect would deprive him of his property rights to a greater extent than is reasonably required to protect his interests. So I think the principles of these cases establish that estate plans will be approved by the court if they create tax savings or benefits for the grantor's estate or family, as long as the interests of the grantor are protected to the extent possible or most reasonably possible to protect their interests and to not deprive them of the care that they might need in the future. So those are my comments.
So that concludes the presentations. We do have a little bit of time if anybody wishes to raise questions, but I think anybody also shouldn't be embarrassed to be walking out as well if they have to go now. Yeah.
I have a question for Joseffer. It's very common that you'll do wills up for a couple or a parent that have kids there in the U.S. At what level of bequest do U.S. taxes kick in on the beneficiary?
Okay, well, The tax is not actually imposed on the beneficiary on receiving the gift, and assuming, say, we have, you know, Canadian donors or decedents, and they don't have U.S. property that's being transferred, there isn't any U.S. transfer tax on the transfer. What happens, though, is in the hands of the recipient, the beneficiary, the son, the daughter, grandchild, when that person dies, assuming the assets haven't been, you know, consumed or dissipated or whatever, then there would be wealth that would be transferred in that person's estate. So it's sort of an advanced planning type of scenario, but sometimes those events transpire more quickly than we would expect.
There's no problem with the gift tax on the U.S.
Okay, well, the gift tax is a separate matter in a way. It's a unified transfer tax system, estate and gift. The gift tax is imposed in a situation where it's a Canadian individual, not a U.S. citizen, making a transfer of property to a U.S. beneficiary. If it's not U.S. situs property, such as real estate or stocks in a U.S. company, then there's no U.S. gift tax that's imposed because it's a non-resident making the transfer. But the gift tax could be imposed if the Canadian parent, you know, transferred as a gift an interest in a Florida condominium to the child. But in both of those situations, the tax is imposed on the transferor. But in terms of the gift tax, the concern is that if then down the road the U.S. individual, you know, has an estate that is building up and is subject to tax, you know, that's a disadvantage. And oftentimes the situation is one where, you know, people are of comparable ages or near comparable ages. And that was why I picked sort of the illustration of the spouses, because that's a pretty frequent one. But with the mobility of people these days, we're seeing a lot of exactly what you're pointing out, which is the children, you know, relocate and may relocate several times.
Okay, thanks. Yeah.
I was just wondering, when you're getting ready to cut the check for compensation to the executives, do you just give it in one lump sum, or if it's a large sum, are you required to consider the tax consequences to the executors? Are you supposed to try and split it up somehow?
Okay, we've lost our executives compensation persons. Anybody want to volunteer a response to that? Archie, how about you?
I'd probably be the wrong person to put that question.
So, but wait a minute, what is the question? That
Well, if the executor's compensation is going to be fairly large,
Yep.
I gather it's taxable to the executor.
Yep.
Compensation tax.
Yep.
So if they get the whole lump sum all at once,
Oh, I
it's
see.
a fair whack of tax.
Yep.
So do you give them all that at once, or do you try to split it up somehow?
Well, okay, when you say do you give it to them, because of course the executors are the persons who have control of the estate, and they only have entitlement to compensation either pursuant to a term of the will or other trust instrument, or the agreement of the beneficiaries, or an order of the court. And they don't, subject to the trust instrument, have a right to pre-take compensation. So on that basis, they typically would only be entitled to it as a lump sum when it has been ordered. Although, of course, in practice, they often do pre-take it prior to being authorized to do so, but are doing so at the risk that they could be said to have done it in an unauthorized way and have to pay interest on the money that they've received prematurely. Yeah.
If there's I have an example. I've got a client, she's named an executor. There's a $500,000 bank account with a single beneficiary that's a religious organization. And there's a prior will where two relatives were named as beneficiaries. We're probably going to make a deal where the beneficiaries get the money that they were intended with the prior will, and the rest of it goes to the religious organization. Assuming the bank will release the funds without probate, do I need to get probate, or is my client at risk as the executor for some stranger coming in?
My answer to that would be that one of the things people often forget about probate is that probate is the protection to the executor, and for that matter, other persons dealing, on the footing that unless and until it's revoked, and if you're acting in good faith, you can't have personal liability if you act in accordance with the terms of will which has received probate. However, if you make a distribution under what you believe to be the last will, which has not been given probate, and it turns out it wasn't a valid will, and somebody does come out of the woodwork who's able to challenge it, you are liable for that wrongful distribution. Yep, subject to...
Don't worry about the, pay the 5,000 or 6,000.
Yeah, you may be able to get restitution back from the wrongly paid persons, or you may not be able to do that. And you may get, the court may give relief under Section 35 of the Trustee Act, but not necessarily. So I think you need to be very confident that there aren't any possible people in the woodwork. But often you can be confident about that. One more, then we should finish.
Jennifer, would you care to comment on the power of an attorney to make gifts or forgivable gifts or loan to beneficiaries in the will when incompetent person dies?
I think that's covered by the Substitute Decisions Act provisions that provide that gifts or loans to friends and relatives can be made if the person expressed an intention to make them well capable. And I guess query whether the naming of somebody in a will is an intention to actually make a gift during lifetime. I would say it's probably not, because a will can be revoked at any time prior to death. I wouldn't rely on that as necessarily as evidence that they would have intended to have made a gift.
That's assuming
true.
they don't ever recover.
Yeah.
Well, yes.
Yeah, and the cases, the courts in the cases that I reviewed do put a fair amount of emphasis on the possibility that a person may miraculously recover, even when they have something that you would think is, not, the likelihood is not great. That's always something that the attorney has to take into account, is the possibility that someone might recover and want to unwind what's been done for them.
And again, assuming that that is the last valid will, and which you don't know for sure until it's got probate, which you won't have had at that stage. Well, let's finish there. I'd just like to finish by thanking this audience, and particularly those of you who are still here, for your tolerance and amiability. And it's been a pleasant afternoon. Thank you.